Today, we will present our business soul report. I'm Chongjing. My group mates are Xiu Xiang, Chen Xiaofen, Ng Xiu Xuan, Tan Fei Yin, and Yong Pui Man.
Firstly, I will start the presentation by making an introduction. The number of criminal activity in business has increased, particularly in this recent decades, and it has been a risk or threat for a company in establish a secure working environment. The English Oxford Dictionary in 2019 defined crime such as an action or omission which constitutes an offense and is punishable by law. It was needed to be on their guard as prevention in avoiding the effect of criminal activity from impacting profitability to the point that the viability of their business comes into question. Crime in business have a wider scope of items to be studied. In this project, we pay much attention to the crime in business cases such as insider trading, money laundering, criminal breach of trust, misrepresentation, and fraud. The next following will discuss more on the following cases with the relevant case review.
This case is about the chairman of 3A Resources Berhad were charged under insider trading. Dato Muhammad Noor Abdul Wahid were charged under Explanation 2A to Section 188 of the Capital Market Service Act 2007 at the Kuala Lumpur Section Court for acquiring 500,000 units of 3A shares. Therefore, the issue has arisen when the SC alleged that the inside information related to the proposed collective venture between the businesses of 3As and Walmart International Limited. Azuzai Zamani, the second defendant, was charged for allowing Dato Muhammad Noor Abdul Wahid to effect the acquisition of the 3A shares in his account, an offence under Section 29A of the Security Industry Act 1991. Dato Muhammad Noor Abdul Wahid and Azuzai were granted bail of 50,000 ringgit with one surety respectively. In conclusion, I agree to both sections in these cases because Dato Muhammad Noor Abdul Wahid acquiring 500,000 units of 3A shares and Azuzai Zamani allowing him to effect the acquisition of the 3A shares in his account. It's about Goh Keng Huat and Wee Siew Ling. Goh Keng Huat, the head of equity market at Sam Bankers Malaysia Berhad, and his wife Wee Siew Ling were charged under Explanation 2A to Section 89E of Security Industry Act 1983 at the Kuala Lumpur Section Court for acquiring 851,000 units of Root Builder Holdings shares. Goh Keng Huat was alleged to have acquired the RHB shares while the trading accounts belonging to her wife. XC also preferred charge against Wee Siew Ling for allowing her accounts to be used by her husband for the purpose of getting the said shares. The issue arises when SC alleged that the non-public information refers to in all the charges related to the proposed gaining of all assets and liability of RBH by IJM Corporation Berhad at a total indicative purchase consideration of approximately 1.56 million. Insider trading is punishable with imprisonment term up to 10 years and a fine of not less than 1 million, and the case has been fixed for mention on 6 December. In my opinion, I agree Explanation 2A Section 89E of Security Industry Act 1983 apply in this case because the husband Goh Keng Huat acquiring 850 units of Root Buildings holders shares while her wife Wee Siew Ling for helping him by allowing her accounts to be used for the purpose of getting the said shares.
My case review is about money laundering. My first case is regarding about Dr. Hamimah became the first person to be convicted under the Anti-Money Laundering Act 2001. Dr. Hamimah was charged because she was manipulating her staff with sending one Abi Zabian to falsify financial documents and promissory note, which resulted in a sum of 41.3 million being transferred into her own account. But she had appealed against the court conviction. Dr. Hamimah was charged under the Explanation 1 to Section 4 of Anti-Money Laundering Act It says that any person who engage directly or indirectly in a transaction that involves proceeds of an unlawful activity or instrumentality of an offense. The offense under this section because Dr. Hamimah was received 41.33 million in illegal gains into her personal bank account. According to explanation 1 section 4 of the Anti-Money Laundering Act, any person commit a money laundering offense and shall on conviction be liable to imprisonment for a term not exceeding 15 years and shall be liable to a fine of not less than 5 times the sum or value of the proceeds of an unlawful activity or instrumentality of an offence at the time the offence was committed, or 5 million ringgit, whichever is the higher. From my point of view, is the criminal punishment to be considered as reasonable because the defense failed to raise any reasonable doubt against Dr. Hamimah at the end of the case. Then, another case is regarding about bank officers were charged in the section court with 1 count of accepting a bribe of more than 219,000 ringgit and 9 count of money laundering. Rai Chin-siang was charged because accept of the bribe from an individual will bank transfers to his account as an inducement for him to approve a loan to purchase a factory. He also transferred the bribes received into his own account and 6 other accounts at the same bank. According to Section 16 of the Malaysia Anti-Corruption Commission Act 2009, means corruptly solicit or receive or agree to receive for himself or for any other person. The offense under this section because Rai Chin-siang will accept the bribe from him to approve the client loan to buy a factory. The penalty under are maximum 20 year imprisonment and a minimum fine of 10,000 ringgit or 5 times the value of the bribe. By referring to the case 1, he will punish imprisonment for a term not exceeding 15 years and a fine. From my point of view, in this case study is they have enough evidence to prove that Rai Chin-siang really committed in money laundering. He should be sentenced with reasonable punishment.
Case 1 is about U Mobile with Asmira Arifin. Asmira Arifin is a former manager at U Mobile. According to the first charge, she committed criminal breach of trust over 720,000 ringgit. For the second charge, the committed criminal breach of trust involving 570,000 ringgit. The charge under Section 408 of the Penal Code carry a maximum jail term of 14 years and with wiping and fine upon conviction. Session Court sentenced Asmira Arifin to 5 years jail of each offence. In conclusion, I agree Section 408 apply in this case because Asmira Arifin embracing about 1.3 million ringgit of the telco company daily collection. Case 2 is about Yap Oi Lee admitted to criminal breach of trust. Yap Oi Lee is a former lawyer. She admitted to criminal breach of trust on a stakeholder sum totaling 59,000 ringgit, which is money from a house loan by Muhammad Burhanuddin Jafarullah for the purpose of purchasing a unit of a house. The charge under Section 409 of the Penal Code provides for imprisonment between 2 and 20 years and possible fine. Sessions Court sentenced Yap Oi Lee to 9 years in the jail. In conclusion, I agree 409 applied in this case because Yap Oi Lee admitted to criminal breach of trust involving the sale of a house.
My case study reviews is misrepresentation. Case studies 1 is about federal misrepresentation. The case was that Hu Qinglong filed a work with the industry Kiom due to the relation of his dismissals by the company Kingsat Electric Corporate Sharika Berhad. The plaintiff misrepresentation his work experience and past salary to the defendant in order to attempt employment. The case laid down in the explanation 3 to section 20 of the Industry Relations Act 1967. The related ministers have the responsibility to decide whether the case should be referred to the industry court. So I think that the defendants have totally enough evidence to cancel the positions of the plaintiff.
The second case is about misrepresentation before making the contract. In these cases, Lai Gui-ming is the plaintiff and Ho Kim-sing is the defendant. Their relationship with contractual agreements is related to the land. It was confirmed that the defendants have an untrue statement that he could assist the plaintiff to address the Chinese buyer to purchase the land at a profitable price. Therefore, the plaintiff succeeds in being induced by the defendant to sign the memorandum of transfer. This case was fully regulated in Section 18 of Contract Act 19,050 deal with misrepresentation and covers situation of innocent misrepresentations. Finally, the contract of land between the plaintiff and defendants is varied, but the defendant needs to compensate in the statement of claim.
My topic review of case is fraud. Case 1. This case is regarding about the 4 former directors of Patimas Computer Berhad were charged in 5.1 million fraud case because the payment were not used for the purpose in the development of various software. They were charged by the Cyber Court on 10 counts of fraud that causing losses to the company 6 years ago. They were charged under Section Explanation 1A to the 317 of the Capital Markets and Services Act 2007. Read together with the Section 34 of the Penal Code, which carries a maximum imprisonment of up to 10 years and a maximum fine of 10 million if convicted. Explanation 1A to the section of 317 of the Capital Markets and Services Act 2007, which a director or an officer of listed corporation or any of its related corporation shall not do or cause anyone to do anything with the intention of causing wrongful loss to the listed corporation or any of its related corporation, irrespective of whether the conduct causes actual wrongful loss. In my opinion, Section 317 of the Explanation 1A of the Capital Markets and Services Act 2007 is enforceable and valid to charge on the 4 former directors of Patimas Computer Berhad for the 5.1 million fraud case. Case 2 is regarding a businessman was charged with fraudulent disposition of property worth 35 million to avoid paying his debts. Lim Kui-gi, 43, was the defendant in this fraud case. 7 of the charges were for transferring property belonging to MegaFair Sendirian Berhad to himself, his company and another person to prevent distribution of the asset to his 8 creditors. The other 12 charges were for the dishonestly preventing the property belonging to MegaFair Sendirian Berhad and from being made available to the creditors by transferring the property to his name, his company and another person. So, he was charged under Section 421 and 422 of the Penal Code, which provide an imprisonment for up to 5 years and fine if found guilty. Section 421, which is dishonest or fraudulent removal or concealment of property to prevent distribution among creditors. Whereas Section 422, which is dishonestly or fraudulently preventing from made available for his creditors a debt or demand due to the offender. Therefore, Section 421 and Section 422 can be enforced to charge on the businessman who has been committed in fraudulent disposition of property worth 35 million to avoid by paying debts.
In conclusion, this paper has discussed about the business criminal cases on a perspective of business law and concept. The outcome of this study provides us the raw knowledge that need to analyze the problem truly and arrive at a correct conclusion. It also found that business law, rules and regulations are essential for everyone that involved in business process to follow.